Good morning, Your Honors.
Good morning, Mr. Anderson.
Good morning, Your Honors.
And Mr. Blevins has joined us. All right, we are ready to go. Mr. Blevins, you have the floor.
Thank you. May it please the court. I'm Jerome Blevins. I represent the appellants, the University of South Florida Board of Trustees and Sundome Inc. in this appeal. If I may, I'd like to reserve 5 minutes for rebuttal.
That'll be fine. Thank you.
Thank you. Your Honors, this is an appeal of the denial of our motion for summary judgment based on the issue of sovereign immunity. The basic facts behind this case are that Ms. Dory, the plaintiff, was injured when she failed to safely step down from a platform into the front row of Section 205 of the Sundome. Her testimony was that she was able to see a black stripe that was at the edge of that platform.
Mr. Blevins, let me jump in here on the
Yes,
assumption that we've all read the facts. Unfortunately, it was difficult to review this case because we have no transcript from the summary judgment hearing. We have no findings by the trial judge who presided. So I'm really struggling with how we could ever reverse this case without the basic tools that we use that tell us what happened below.
Judge, I would submit to the court that this is a case where the facts that are in front of it, that were in front of the judge and that are not controverted, established that she saw the black stripe and that the stripe was part of the design of the Sundome. And for that reason, the defendants are entitled to summary judgment. We did have a court reporter standing by, but for some reason she was unable to get into the Zoom meeting, and we did not realize that, and I was not informed until after I had already concluded my argument to the court.
I guess I would add to the list of issues that I mentioned earlier, the fact that a number of depositions were taken, which were argued in the initial brief, which actually weren't even in front of the court.
That's correct, Judge, and I apologize.
It's almost like this case needs to go back. It wasn't ready for summary judgment and needs to go back and have a court reporter and some depositions filed and a record so that we can figure out what happened.
Judge, I don't necessarily disagree with that position. It was frustrating for me because when I found out the court reporter was not available. And I will acknowledge that filing the other transcripts was not my finest legal moment. I apologize to the court for any additional time that may have consumed, both for them and for you and for opposing counsel. That I think what I got caught up in was we were proceeding toward a trial that was at that time set in May. There were a number of depositions that were taken. This was an interlocutory appeal, but I mixed that up and said, well, I need to give a full record to the court. And so that's why I did submit those. If you notice from my brief, though, I did not really argue any of the facts from that additional evidence that was not before the judge and therefore not supposed to be before this panel as well. I focused on Ms. Dory's testimony. I believe that establishes that we are still entitled to summary judgment because her testimony was she saw the black stripe at the edge of the step and that she was looking down when she was walking. She wasn't distracted by anything. She was being careful. We are asking for a ruling that we're entitled to sovereign immunity based on the line of cases that says that the state, although there is a waiver of sovereign immunity for certain purposes, it is not waived under these circumstances. And the university—
There are some exceptions, however, to the sovereign immunity grant.
That is correct, Your Honor.
So if you have a known dangerous condition or an existing unsafe condition or a failure to warn or different things like that. And here's where I have an issue. I can't tell what was argued that defeated the summary judgment because there's no record.
Yes, sir. Well, I would submit to the court that what was argued was that there should have been a different warning. Not, and in fact, that seems to be the premise in the plaintiff's reply brief, is that the warning should have been different, or that there should have been additional lighting that was shining directly onto that particular step. Both of those would be design issues. Both of those go to the design of the sun dome and are immune from liability. So what they're saying it's a failure to warn, but it's really, they don't like the type of warning that was provided. And that's what their case seems to be predicated on, is, oh, well, there could have been a different kind of warning. It could have been a different warning on the step. This was a black strip. That's something that they have noted in their brief, that says this was a black strip and that's not a sufficient warning. Well, it was a black strip on as clearly indicated in the video that's attached to the plaintiff's deposition, it was a black strip on a light colored ground or surrounding area. So it was a contrasting color.
It seemed like another point that the plaintiff was making was that as you descend the steps in this particular part of the stadium, you go down a series of steps, and I looked at all the pictures that are in the record, and then you come to a sort of a platform type situation at the bottom of the steps. And then the plaintiff is saying when the plaintiff took a right turn to be seated, unexpectedly there was a drop off. So if, like, for example, would that be a known dangerous condition that there should be a warning for, other than, in other words, there's a number of things that are being alleged apart from the black strip of tape, which in and of itself does raise a little bit of concern about, it's kind of dimly lit to walk down those stadium stairs, and is that sufficient? I guess I'm just throwing facts out there which in effect highlights the issue that I think our panel, I won't speak for them, at least for me, that I was trying to sort out. So go ahead. I'll try not to interrupt you again.
Oh, certainly. If you have any questions, please interrupt. The stripes at the front edge of those steps were the warning. The university, recognizing that there is a potential for people to fall on steps, put those stripes at the very front edge of those steps to alert them to the fact that there is a change in elevation. It was the same way with this last platform. There was a stripe right at the edge of it to alert anyone that there is a change in elevation. And this is not a question. This is not like some of the cases where they say, oh, there was no way to distinguish between the Aaron versus Palatka Mall case, where she couldn't distinguish between the curb stops and the surrounding area. The stripe is clearly visible because it's a contrast to the surrounding area, and that is part of the design of the arena, and that is immune from liability under the case law. It's not the purpose of the courts, as noted by Nielsen and by Ingham and by Coney, to impose the decisions of a jury or a court on the decision-making processes of a state or state agency when it comes to issues of design. And what I would submit to the court is that this is truly a design issue, and this is what their complaint goes to. That is the very crux of what their complaints are going to, is our design, our choice for lighting, the different lights on the edge of the seats as she descended the stairs, the fact that there is not a light on that directly shining onto that bottom step is, once again, that is a design. That is the design of the arena. In the Coleman case, which deals with the failure to warn, the duty is to warn of a dangerous condition that is not readily apparent. Well, this was apparent to the plaintiff. She acknowledged that she saw the stripe. She understood as she went down those steps that there was a stripe at the edge of each step. I think it was best described by Justice Kogan in the Coney decision, in his concurring opinion, which was adopted by the second DCA in the Stevens case, that what Colum and Nielsen are talking about are known hazards so serious and so inconspicuous to a foreseeable plaintiff that it virtually constitutes a trap. This was not a trap. This was a step. And it was marked at the edge of the step, as were all the other steps in that section. And so we would submit that the plaintiff was herself obligated to exercise a reasonable degree of care for her own safety. That's from the Supreme Court in Matson versus Tip Top, and in that she had a duty to observe what was obvious. And in fact, she did observe it. She just failed to safely negotiate the step. I think that's really all I have to argue to the court. I would like to conclude unless there are other questions.
Thank you, Mr. Blevins. Okay.
Good morning, Your Honors.
Mr. Anderson.
Yes, Your Honors. May it please the court, I'm Scott Anderson with the law firm Johnson, Dayball, and Anderson. I'm here on behalf of Appleese. You know, it's difficult when we have the record that we do have to be here arguing on motions for summary judgment. But I think a lot of what Mr. Blevins hit on, frankly, has nothing to do with immunity. For example, whether or not the black stripe was an adequate warning, that's clearly a factual issue for a jury to determine. The complaint alleges that the creation of the stairway created a dangerous condition that was known or should have been known, and therefore there was the obligation to warn. Now, whether the black stripe is a warning at all is a fact issue. Whether or not the black stripe at all is an adequate warning is a fact issue. But as Your Honors will see in the complaint, there's also issues about the control of the lighting. And there's evidence that USF controls the lighting during these events. It's also our contention that the opera lights that light up each of the steps are in and of themselves warnings. Once you create the unreasonably dangerous condition or the dangerous condition, you have a duty to adequately warn about it. And those are the allegations here. Those are the allegations in the complaint. Those are the consistent with the testimony of Ms. Dory, who's the only, and that's all that was before the trial court, frankly, was the complaint and Ms. Dory's testimony and Ms. Dory's discovery responses. And based on that alone, denial of the summary judgment was proper. Now, in addition to not being entitled to immunity, I think there are issues that, and frankly, I think that's the only issue that's properly before the court on the statute, the denial of a motion based on sovereign immunity. I think whether or not there's sovereign immunity is the issue before the court. I'm not sure this is the right place to be arguing the adequacy of warnings. But we certainly take the position that a black stripe on a stair that's different than all these steps preceding it, as alleged in the complaint and as testified to by Ms. Dory, is a dangerous condition. And there's a duty to warn of that. Now, she testified that she saw the black tape. What she didn't testify to and what she contends is that black tape didn't indicate to her and she couldn't appreciate the change of elevation as she was walking into the row. Simply seeing the black tape itself does not mean that she saw the change of elevation. It doesn't mean she knew that there was a change of elevation coming. It simply means she saw black tape. And as she testified, as she was walking down the steps, her cues were stuff like the lighting. Some of the lighting that was controlled by USF from up top, some of the opera lights, but the circumstances there created an unreasonably dangerous condition of which there should have been an adequate warning. And I don't think under the circumstances that the summary judgment can be reversed. She testified she was walking very carefully. That's in the record. She testified that she was paying attention. That's in the record. She testified that she saw the black stripes. That's in the record. But she also testified she didn't see the change of elevation. She did not see the steps. And that in and of itself should raise the fact issue of whether or not that black tape is an adequate warning that there's a change of elevation coming. And I'm happy to answer any questions that the panel has, but I think the crux of the issue is, given the allegations in the complaint and given the testimony of Ms. Dory, whether the appellant was able to establish that they were immune. And under these circumstances, I think the record is clear that they're not. And I'm happy to answer any questions. I also think it's important to note that the additional evidence that was filed with the court also supports this. For example, everybody who's testified in this case has testified that that last step is different than the steps that preceded it. Both of plaintiff's experts, USF's corporate rep, they all testified that that step is different. And what we also know, and what Ms. Dory testified to, is that throughout the Sun Dome, there's other areas that have luminescent striping or bright black and yellow striping. And that striping is there because those steps are different. Here, they didn't do that. And that's not an adequate warning. And based on the evidence before the court at the time, and even based on the evidence as it stands now, summary judgment was inappropriate because there's clearly fact issues as to whether or not an adequate warning was received. There's clearly fact issues as to the dangerous nature of the condition. The case is littered with fact issues. But what isn't an issue is what the complaint says, which is that USF created an unreasonably dangerous condition and failed to warn of it. And that Ms. Dory testified that she didn't appreciate the change of elevation despite seeing the black tape. And that was what was before the trial court. And based on what's there certainly couldn't be said to be sovereign immunity. And the line of cases that Mr. Blevins discussed, the Nielsen case, the Ingham case, and the Cone case, those are all cases in which the courts found that the design of a roadway is something that shouldn't be disturbed by the courts. The design itself of the roadway, including the placement of traffic signals, that's something that shouldn't be disturbed by the courts, because then the court is going to have to address every intersection in the state of Florida, whether or not it was designed properly, whether or not they put traffic lights up, whether or not there's an appropriate stop sign. That's not what we have here. Here we have a case where a woman is walking down a set of stairs. And the stairs, as she gets to the bottom, she's on a landing, as Justice Black noted. And then she goes right. And she is unable to appreciate that step because there's no warning, but also because every row that precedes her as she's walking down the stairs has a flat entranceway that walks into the row. That's the evidence that was before the court. That's the evidence that's before this court. And that's the evidence, regardless of whether you take it at the time of the summary judgment hearing or whether you take it now, including all the evidence that was filed with the court, including all the plaintiff defendants' expert depositions. That's the state of the case. And the case law makes clear that In the face of allegations and evidence of an unreasonably dangerous condition, that there needs to be an adequate warning in place, or the dangerous condition needs to be fixed or repaired. And unless your honors have any questions, I'm gonna rest there.
Good. Thank you so much, Mr. Anderson.
Thank you.
Mr. Blevins, 5 minutes for rebuttal.
All right, thank you, Your Honor. Your Honors, this goes to the heart of planning level decision of the planning level decision-making process. This was the design of the Sundome. The stripes, there's an affidavit from Roy Clark that was before the trial court that says that the Sundome complied with the building code. Mr. Anderson talked about some of the testimony that was not properly before this court nor for the trial court, but I'm not going to address that. But there's the testimony that was before the trial court was that she walked down those steps, she observed the black stripe at the front edge of each step. She saw the black stripe at the edge of the landing. Yes, it went off at a 90-degree angle from the other steps, but that's also the case at a landing halfway down that section, as pointed out in the video. And there is a step down there and there's no light shining on that step. You can see that in the video. It's not, of course, she didn't appreciate the fact that there was a change in elevation, I assume, because she wouldn't have fallen otherwise, but that doesn't mean that she wasn't given an adequate warning. If, as Mr. Anderson argues, warning is always a issue of fact, then that's all that someone has to say in any of these cases to preclude the state agency from getting sovereign immunity on a design issue. The key or the crux in the warning cases, as stated by Collum and as stated by Justice Kogan in Coney and as adopted by this court in Stevens, is, was it so inconspicuous that she could not observe it? This, and just to, I think, quote Justice Kogan, the step was not a trap, or I would argue that the step was not a trap. It was not inconspicuous. And for that reason, we would be entitled to summary judgment. It was not so inconspicuous as to constitute a trap. Therefore, any duty to warn was satisfied. For that reason, we would ask that the court remand this to the trial court for entry of final summary judgment on behalf of both of the University of South Florida Board of Trustees and Sundome Inc. And with that, I will conclude. Thank you.
Thank you, Mr. Blevins. Thank you both. You may exit our virtual courtroom.
Thank you.
And our last case on the docket this morning is Department of Children and Families versus Florida Public Employees Council 79.
Okay.